And a recap of our top story: residents of Siaya County will today know the fate of two of their leaders when the High Court delivers judgments in two election petitions. Lady Justice Esther Maina is expected to deliver her verdict in the case challenging the election of Governor Cornel Rasanga, filed by former Rarieda Member of Parliament Engineer Nicholas Gumbo. But for now, Lady Justice Esther Maina is currently giving her verdict in the GEM parliamentary election petition against Elisha Odhiambo, filed by former GEM legislator Jakoyo Midiwo. Let's cross over there and listen in.
But rather relied on what he was told by someone. When questioned about it, he refused to disclose the source of his information. His evidence, therefore, was hearsay, which in my finding is neither trustworthy nor reliable. It is also my finding that whereas the second respondent's contract of employment forbids him to do business while in the employment of the commission, the same permits him to be a normal shareholder for investment only. Therefore, to assert that he could not even partake of dividends of his investment as a shareholder is stretching the terms of his employment too far. I do not therefore agree with the submission that the second respondent acted unlawfully by earning dividends from the company. More importantly, there was not even an iota of evidence to suggest that the second respondent's judgment or decisions, either in the period before the election or on the day of the election, were clouded with prejudice against the petitioner and in favor of the third respondent. There were 168 polling stations in the constituency, and admittedly, the petitioner had an agent in every one of them, and there was no evidence that the second respondent interfered with the voting in any of the polling stations so as to favor the third respondent, to favor or give advantage. To the contrary, we have evidence from, there was one witness, Saulo Owino Liseno, who was PWE, who was the petitioner's agent at Mwadi polling station, that he did not see IEBC favoring anybody. It is my finding, therefore, that the petitioner's apprehension of bias on this account was not reasonable. In any event, he told this court that when he encountered problems on election day, he liaised with the second respondent and the same were resolved. As regards Bukangesa PW6, it is worth noting that in his affidavit, the only allegation he makes against the second respondent is that on 2nd August 2017, the second respondent had planned a meeting with the third respondent. So the court has quoted the paragraph 4 and 5 of his affidavit. Bukangesa met third respondent at Madea VIP Hotel on 31st July 2017. A reading of paragraph 4 above shows that it is based on what he was told. During cross-examination, he stated that he learned about it from a teacher. He, however, refused to name the teacher, saying he could not disclose the source of his information. As stated earlier, given that the said teacher was not called as a witness, that evidence is hearsay and cannot form the basis to invalidate this election. His allegation that the second and third respondent met at VIP Hotel is contained in a letter he wrote to the county returning officer on 2nd August 2017. Notice, however, that it does not state that he was in that hotel on 31st of July or that he personally saw them, which is what he alleged in court. In my opinion, it is doubtful that he did. If he did, why did he not expressly state it in the letter and deposit in the affidavit? The answer is that it was most likely untrue. A closer reading of his affidavit and the letter annexed thereto reveals that this witness was reacting to rumors. His evidence falls below the standard required to prove the allegation he makes, let alone bias. Who is this man taking? Are you a reporter? Huh? Then why are you on that side? Can you stop taking the proceedings? The petitioner also alleged that the recruitment of the second respondent, presiding officers and clerks was not transparent, and that the list of those the commission proposed to recruit was not availed to him as is required under regulations 3.2 and 3.4 of the elections general regulations, and therefore the election breached the principles in the constitution and the law. Regulation 3.2 enlists the Commission to share the list of those it proposes to appoint with political parties and adequate and independent candidates at least 14 days prior to the appointment to enable them make any representations. Regulation 3.4 requires that the appointment be done transparently and competitively and thereafter be gazetted. The court heard that the second respondent was first appointed to the Commission in 2016 as an administrative assistant and was gazetted as a returning officer on 31st of May 2017. The petitioner is, on the other hand, on record as stating that he became an independent candidate in June 2017. By then, the second respondent had already been gazetted as the returning officer for this election. It also transpired that the issue of the appointment of returning officers was litigated before Justice Odunga in Nairobi, where the NASA coalition had sought leave to commence judicial proceedings to quash the decision of the first respondent in the manner in which they had appointed the returning officers and the county returning, or the constituency and the county returning officers. The parties in that case filed a consent order, which kind of now revived the issue so that the candidates were given an opportunity to make their representation. But according to the petitioner, he did not make any representation. So this court found